Yeah, it shouldn't have hit the button. Or, got it. Okay. I mean, it's on the Zoom, Laura, but I can't. It's. We good? Oh, they're still signing. Sorry. I think it'll be easier. We'll just need to make sure you talk into the microphone.
We have one question of the sheriff's department. We want to know if they should sit closer to the microphone.
Is it okay if, yeah,
They said it's okay.
that's fine, okay. All right, we are ready to go forward with the pleas for Mr. Ott, Mr. Williams, and Mr. Jones. Mr. Ott, can you please stand up and then raise your right hand to the best of your ability? You swear or affirm the testimony you shall give in this matter now pending will be the truth, the whole truth, nothing but the truth, under penalty of perjury.
Yes, ma'am.
You can lower your hand and sit down. Mr. Williams, will you please stand up and raise your right hand to the best of your ability? Do you swear or affirm the testimony you shall give in this matter now pending will be the truth, the whole truth, nothing but the truth, under penalty of perjury?
Yes, ma'am.
Lower your hand. Mr. Jones, will you please stand up? Do you swear or affirm the testimony you shall give in this matter now pending will be the truth, the whole truth, nothing but the truth, under penalty of perjury? You can lower your hand and sit down. All right, go ahead, Mr. Body.
And Mr. Ott, are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there any medication that you take normally or on a daily basis that you did not take today?
No, sir.
And do you understand that you're here to enter into a plea for the counts negotiated on this indictment?
Yes, sir.
And Mr. Williams, are you at this time taking under the influence of any alcohol, drugs, or medicines?
No, sir.
Is there any medication that you take normally or on a daily basis that you have not taken today?
No, sir.
And you understand that you are here to enter into a plea as to the counts negotiated through your counsel?
Yes, sir.
And Mr. Jones, are you at this time taking under the influence of any alcohol, drugs, or medicine?
No, sir.
And is there any medication that you take on a regular basis or daily that you have not taken today? Yes, yes or no?
Well, yes, but it's not affecting how we handle this.
Okay, so the answer is yes.
The answer is yes, he has high blood pressure medication that he has not taken yet today.
And the medication that you didn't take, that you regularly take on a daily basis, does that affect your ability to understand what you're here for today?
No, sir.
And do you understand that you're here to enter into a plea to the counts on the indictment negotiated by your counsel, Ms. Cobb?
Yes, sir.
And Mr. Ott, how old are you and how far have you gone to school?
26, 10th grade.
And Mr. Williams, how old are you and how far have you gone to school?
24. Got my GED.
And Mr. Jones, how old are you and how far have you gone to school?
24. I received my GED while being incarcerated. So,
Oh, it's not on?
Hold it up, yeah. Okay, is it green now?
It's green now.
You're 24, and
Yeah.
then how far have you gone to school?
I received my GED while being incarcerated.
And Mr. Ott, are you able to read, write, and understand English language?
Yes, sir.
And Mr. Williams, are you able to read, write, and understand English language?
Yes, sir.
And Mr. Jones, are you also able to read, write, and understand the English language?
Yes, sir.
And Mr. Ott, do you understand that you're charged with the following offenses? In indictment number 18 SC 158565. And for the record, for your honor, the state would intend to do as we did during the plea with Mr. Bailey. The state would be moving to null cross counts 1, 2, and 9. And then as it pertains to Mr. Jones, count 31. As it pertains to Mr. Ott, count 31, 32, and 34.
I'm sorry, say it again. Start.
So all three defendants, the state will move to null cross counts 1, 2, and 9.
Okay.
And then specifically to Mr. Jones, count 31. Specifically, Mr. Ott would be count 31, 32, and 34. And then lastly, Your Honor, as it pertains to Mr. Williams, count 31 and 32. Now, Mr. Ott, do you understand that you were charged in this indictment, additionally to the counts the state just discussed, counts 3 through counts 11, counts 3 through 11. Actually, you are 3 through 9. Felony murder, you understand that you're charged in those counts as felony murder.
Yes, sir.
You also understand, Mr. Ott, you are charged in counts 12 and count 13, armed robbery,
Yes, sir.
and then counts 14 through count 18, aggravated assault with a deadly weapon,
Yes, sir.
and count 19, kidnapping with bodily injury.
Yes, sir.
And as your counsel informed you, that the state intends to move forward with the kidnapping charge, which is 10 to 20.
Yes, sir.
You also understand that you are charged in counts 20 through 24 false imprisonment,
Yes, sir.
and then counts 26 smash and grab burglary. Let's get count 25, which is burglary in the second degree. You understand that you're charged with those 2 burglary counts.
Yes, sir.
Count 27, hindering a person making an emergency telephone call,
Yes, sir.
and then count 28, hijacking a motor vehicle,
Yes, sir.
count 29, armed robbery,
Yes, sir.
and then count 30, aggravated assault with a deadly weapon.
Yes, sir.
You understand the state intends to motion the court to nullify counts 31, 32, and 34.
Yes, sir.
Mr. Williams, do you also understand that you were charged in counts 1 through 9 as well, felony murder counts?
Yes, sir.
Mr. Williams, do you understand that you are charged in counts 12 and 13, both armed robbery counts,
Yes, sir.
and counts 14 through 18, all being aggravated assault with the deadly weapon counts?
Yes, sir.
And count 19, similarly as your co-defendant, Mr. Ott, you understand the state intends to reduce that count from kidnapping to bodily injury, to kidnapping, which would make it so you would have a minimum sentence of 10, a maximum of 20 years for that charge.
Yes, sir.
Do you also understand, so that you are charged in counts 20 through 24 false imprisonment,
Yes, sir.
and counts 25 burglary in the second degree, and counts 26 smash and grab burglary? You understand that you're charged with those two burglary counts?
Yes, sir.
Count 27 hindering a person making an emergency telephone call,
Yes, sir.
and count 28 hijacking motor vehicle,
Yes, sir.
count 29 armed robbery,
Yes, sir.
count 30 aggravated assault with a deadly weapon.
Yes, sir.
You understand the state intends to motion the court to nullify count 31, count 32.
Yes, sir.
Mr. Jones, you also understand that you were charged in counts 1 through 9, all being felony murder counts,
Yes, sir.
and you understand that in counts 12 and 13, you're charged with armed robbery,
Yes, sir.
and in counts 14 through count 18, all those counts being aggravated assault with a deadly weapon.
Yes, sir.
Count 19, just as your co-defendant, you're charged with kidnapping and bodily injury. State intends to present the court with reduced count of just kidnapping, which would make the minimum penalty 10 years, the maximum be 20 years.
Yes, sir.
Do you understand you are also charged in count 20 through 24 with false imprisonment,
Yes, sir.
and count 25 and 26, count 25 being burglary in the second degree, and count 26 being snatch and grab burglary?
Yes, sir.
And do you understand the state intends to motion the court to nullify count 31?
Yes, sir.
Now, Mr. Ott, Mr. Williams, and Mr. Jones, do you understand that you all have the right to be either guilty or not guilty to these charges, and if you pled not guilty or remain silent, you may receive a jury trial? Mr. Ott,
Yes, sir.
Mr. Williams,
Yes, sir.
Mr. Jones,
Yes, sir.
and Mr. Ott, Mr. Williams, and Mr. Jones, have your attorneys explained to you the rights that you're waiving or giving up by entering a guilty plea here today?
Yes, sir. Yes, sir.
Yes, sir.
And Mr. Ott, you need any additional time to discuss the case with your attorney?
No, sir.
And Mr. Williams, do you need any additional time to discuss the case with your attorney?
No, sir.
And Mr. Jones, do you need any additional time to discuss any aspect of the case with your attorney?
No, sir.
Mr. Ott, Mr. Williams, and Mr. Jones, are you satisfied with the services of the council? So, Mr. Ott, are you satisfied with the services of Mr. Hoover?
Yes, sir.
And Mr. Williams, are you satisfied with the services of Mr. Francis?
Yes, sir.
And Mr. Jones, are you satisfied with the services of Ms. Kaufman?
Yes, sir.
And Mr. Hoover, Mr. Francis, and Ms. Kaufman, you waive formal reading of the indictment?
So waived.
Yes.
Yes.
And Mr. Hoover, Mr. Francis, and Ms. Kaufman, do you waive any and all defects in the indictment, including any with respect to your client's name for the purposes of this hearing or this plea?
Yes, so waived.
Yes.
Yes.
Sheriff first.
And
Sheriff first.
Mr. Ott, Mr. Williams, and Mr. Jones, your attorneys advised you of the minimum and maximum sentence for each charge you're pleading guilty to.
Yes, sir.
And, excuse me, Mr. Williams
Yes, sir.
and Mr. Jones.
Yes, sir.
So, Mr. Williams, Mr. Jones, as your attorney explained to you, that in counts 3 through 9 of the felony murder counts, the state intends to request that those counts be reduced to voluntary manslaughter, which is OCGA 16-5-2, which has a minimum of 1 year, a maximum of 20 years. Mr. Ott,
Yes, sir.
Ms. Williams, you understand that?
Yes, sir.
And Mr. Jones, you understand that?
Yes, sir.
And Mr. Ott, Mr. Williams, Mr. Jones, do you understand that the counts in the indictment that are armed robbery, you understand that the minimum is 10 years, the maximum is 10 to 20 or life? You understand that, Mr. Ott?
Yes, sir.
Mr. Williams,
Yes, sir.
and Mr. Jones?
Yes, sir.
And Mr. Ott, Mr. Williams, and Mr. Jones, do you understand that the counts in the indictment that are aggravated assault with a deadly weapon, that the minimum is 1 year, the maximum is 20 years for that count, for those counts? Mr. Ott,
Yes, sir.
Mr. Williams,
Yes, sir.
and Mr. Jones?
Yes, sir.
And you understand, as the state explained before, that the state has reduced the kidnapping and bodily injury count, to kidnapping with the maximum is 10 years, the minimum is 20 years. You understand that, Mr. Ott,
Yes, sir.
Ms. Williams,
Yes, sir.
and Mr. Jones?
Yes, sir.
And Mr. Ott, Mr. Williams, and Mr. Jones, you understand the counts that are false imprisonment, the minimum is 1 year, the maximum is 10 years. Mr. Ott,
Yes, sir.
Mr. Williams,
Yes, sir.
and Mr. Jones?
Yes, sir.
And Mr. Ott, Mr. Williams, and Mr. Jones, understand burglary with a second degree has a minimum of 1 year, maximum of 8 years. Mr. Ott,
Yes, sir.
Mr. Williams,
Yes, sir.
Mr. Jones?
Yes, sir.
And you understand, Mr. Ott, that smash and grab burglary has a minimum of 2 years and a maximum of 20 years.
Yes, sir.
And Mr. Williams,
Yes, sir.
and Mr. Jones?
Yes, sir.
And Mr. Ott, you understand that hijacking, hindering a person from making an emergency telephone call is a misdemeanor, so it's a minimum of 1 day and a maximum of 12 months.
Yes, sir.
Ms. Williams,
Yes, sir.
and Mr. Jones?
Yes, sir.
And I apologize, Mr. Jones, you were not charged with that.
Yeah.
My apologies. And Mr. Ott, do you understand that hijacking a motor vehicle has a minimum of 10 years and a maximum of 20 years?
Yes, sir.
And Mr. Williams, you understand that?
Yes, sir.
And Mr. Ott, do you have any questions about the minimum and maximums that I just explained to you, that your attorneys previously explained to you about the count you're pleading guilty to on the indictment?
No, sir.
Mr. Williams
No, sir.
and Mr. Jones?
No, sir.
Now, Mr. Ott, Mr. Williams and Mr. Jones, do you understand that this is at least as it pertains to Mr. Ott, Mr. Williams, this is a joint recommendation to the court, meaning your counsel and state counsel will recommend the sentence of 30 years to serve, which would be on non-parolable offenses. But the court does not have to accept that sentence. It can sentence you as she sees fit, meaning that she can sentence them each count that you're pleading guilty to consecutive or one after another.
Yes, sir.
And Mr. Ott, you understand that? I mean, Mr. Williams.
Yes, sir.
And then Mr. Jones, the same applies to you. You understand that instead it will be a non-negotiable plea where the state recommends 15 years to serve, which would be non-parolable time. And your attorney will request a number of years. But the judge does not have to follow either recommendation and can sentence you to maximum for each charge and run them consecutively, which means one after another.
Yes, sir.
And Mr. Ott, Mr. Williams, and Mr. Jones, you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts.
Yes, sir.
Ms. Williams
Yes, sir.
and Mr. Jones.
Yes, sir.
And Mr. Ott, Mr. Williams, and Mr. Jones, you understand that if you are not a United States citizen, a guilty plea will affect your immigration status and will result in deportation, regardless of any advice given to you by your attorney or anyone else.
Yes, sir.
And Mr. Williams
Yes, sir.
and Mr. Jones.
Yes, sir.
Mr. Ott, you understand that you waive any and all defenses by entering a plea of guilty here today?
Yes, sir.
Mr. Williams, do you understand the same, that by entering a plea of guilty, you are waiving any and all defenses?
Yes, sir.
Mr. Jones, you also understand that you are waiving any and all defenses by entering a guilty plea here today?
Yes, sir.
Mr. Ott, Mr. Williams, and Mr. Jones, do you understand that by pleading guilty, you're giving up the following rights? The right to trial by jury, the right to remain silent and to not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or court appointed if you are unable to afford an attorney at the trial of your case, the right to presumption of innocence, the right to testify on your own behalf, present other evidence, the right to subpoena witnesses and to compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt by the state of Georgia, and the right to appeal the convicted of the charges at the trial. Mr. Ott, do you understand that you are waiving or giving up all of these rights by entering a guilty plea here today?
Yes, sir.
Mr. Williams, do you understand that you are waiving all of these rights by entering a guilty plea here today?
Yes, sir.
And Mr. Jones, do you also understand that you are waiving or giving up all of these rights by entering a guilty plea here today, sir?
Yes, sir.
And Mr. Ott, has anyone forced or threatened or promised you anything to get you to enter a guilty plea here today?
No, sir.
And Mr. Williams, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today?
No, sir.
And Mr. Jones, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today?
No, sir.
Give us a sit letter.
No, sir.
Mr. Ott, how do you plead to the charges in indictment 18 SC 158-565?
Guilty.
Mr. Williams, how do you plead to the charges in the indictment 18 SC 158-565?
Guilty.
And Mr. Jones, how do you plead to the charges you are indicted with in indictment number 18 SC 158-565?
Guilty.
And Mr. Ott, is this guilty plea freely and voluntarily given with full knowledge of all the charges against you?
Yes, sir.
And Mr. Williams, is this guilty plea freely and voluntarily given with full knowledge of the charges?
Yes, sir.
against you?
Yes, sir.
And Mr. Jones, is this guilty plea freely and voluntarily given with full knowledge of all the charges against you, sir?
Yes, sir.
Yes. Mr. Ott, do you understand that you may only have a limited right to appeal this guilty plea conviction?
Yes, sir.
Mr. Williams, do you also understand that you may only have a limited right to appeal this guilty plea conviction?
Yes, sir.
And lastly, Mr. Jones, do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, sir.
Mr. Ott, do you understand that you have only 4 years from today for a felony charge, 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging this guilty plea?
Yes, sir.
And Mr. Hoover explained to you what a habeas corpus petition is.
Yes, sir.
And Mr. Williams, do you also understand that you have only 4 years from today for a felony charge, 12 months from today for a misdemeanor charge, file a habeas corpus petition challenging this guilty plea?
Yes, sir.
And Mr. Francis explained to you as well the ins and outs of what a habeas corpus petition is.
Yes, sir.
And Mr. Jones, do you also understand that you have only 4 years from today for a felony charge, 12 months from today for a misdemeanor charge, to file a habeas corpus petition challenging this guilty plea?
Yes, sir.
And in the time that you have to speak with your counsel, Ms. Hoffman, she's explained to you what a habeas corpus petition is.
Yes, sir.
Your Honor, I guess you recently heard the factual basis as all three defendants that are taking the plea before Your Honor right now. Previously, when Your Honor took the plea, as Carlos Bailey, so same understands that the record will be supplemented for this plea with the same factual basis that was given for Mr. Bailey. I would additionally add additional facts pertaining to each defendant and how they were identified for the crimes that committed in 2017.
Go ahead.
As I explained to Your Honor during the plea for Carlos Bailey, as after the defendants, Mr. Bailey, Mr. Williams, and Mr. Arjack, victim Clay Anderson, who was a food driver that evening, after abandoning the car near West Shire Place, Your Honor, all three defendants ran from the abandoned vehicle, and as they were doing so, they were as I explained, jumping fences and walls and things of that nature. Both Mr. Ott and Mr. Williams discarded gloves and the masks that they were seen wearing on the video surveillance that they were captured in at the Barcelona wine bar restaurant. Detectives used canine and other means of investigation when they were going through the woods and were able to locate gloves as well as the masks that the defendants were wearing. When the masks were sent to the Georgia Bureau of Investigation, the GBI, the testing was done, and when the DNA that they were able to extract off of the mouth area of both masks, they were able to compare that to the DNA of both Mr. Ott and Mr. Williams, and upon doing so, it was a match of both to the masks that were found and that were previously discarded by each defendant.
Continue.
Your Honor. Also, there was a witness, Your Honor, who was called by Mr. Bailey after Miss Chelsea and Ms. Bellard was shot and eventually killed as the three defendants fled the scene in an attempt to find Terry Jones, who was the driver and knew that the defendants were going to commit the armed robbery in the restaurant district that I explained to Your Honor earlier. When they were unable to do so, as explained, they did carjack Mr. Anderson, but as that was occurring, the phone records that Detective Kevin William Packer went through meticulously after going through upwards of 53,000 calls from the tower dumps, was able to locate the defendant Terry Jones, making several calls in the area. In fact, Ms. Bellard was shot at 2:36 in the morning. The defendants are seen fleeing from the location at 2:38. And it's not Mr. Bailey, Mr. Ott, Mr. Williams who's calling Mr. Jones. It's Mr. Jones who's calling Mr. Bailey. And the state would submit the evidence would be that he's calling Mr. Bailey because he's trying to locate where they are so he can take them from the location in which he had dropped them off for what they had intended to be an armed robbery that led to the murder of this fellow. Furthermore, Your Honor, because Mr. Jones and Mr. Bailey were unable to connect, Mr. Bailey can call a child friend, by Mr. Dante Furlow. Through the review of the phone records by Detective Kevin William Packer, it is clear that when Mr. Bailey called Mr. Furlow was in his home in DeKalb County, which is why Mr. Furlow was not charged, because he had no knowledge of the incident were occurring. He had no knowledge, as he would testify, as to why he was picking up Mr. Bailey and what he would learn when he arrived, his two friends. When he arrived, Mr. Bailey and Mr. Ott, Mr. Williams entered into the vehicle. Mr. Bailey then used Mr. Furlow's phone to call Mr. Jones, where he instructed Mr. Jones to go to Mr. Furlow's home, where Mr. Jones did meet up with the remaining defendants who were in Mr. Furlow's car. And at that point, Mr. Furlow was given $100 for gas money, and the remainder of the funds Mr. Furlow would testify were split. The proceeds of the armed robbery were split between all three defendants, that being Mr. Jones, Mr. Williams, and Mr. Ott. Had this case proceeded to trial, Your Honor, the state would have been able to prove beyond a reasonable doubt as it pertains to all of the facts and the evidence for each defendant that stands before you here today. Your Honor, I will tender the indictment to Your Honor as assigned by the state, as well as counsel for each party and each defendant recognize that they're pleading guilty to counts discussed at the beginning of this plea. As it pertains to Samuel Ott, he does have two prior felony convictions, one out of Rockdale County, felony fleeing for lewd and that I received in 2014, which appears to be pled on the first offender, but that first offender was revoked on June 1st of 2015. Your Honor, he also pled guilty to a complaint by the Superior Court to an entering auto on November 9th, 2015. As it pertains to the criminal history of Mr. Ira Williams, he is not, from my review, his DCI criminal history, any felony convictions. I bring to the court's attention that at the time of this, what led to be a homicide, Mr. Williams was actually out on